Good morning. Según yo ya está bien, ¿no? Hello. Madam President, Mr. President, Your Excellencies, and esteemed agents representing the state of Meghalaya. La, 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 la.
Y la transmisión ya está lista para, ok, pues equipos, público, estamos a punto de comenzar, entonces ya todo esto lo van a entrar los jueces. Ya está por el proceso, ya está pagando, entonces ya está preparada de comisión oral, análisis en parte de los jueces y normalmente empezamos. Pero lo empieza ya. Y el sonido ya. Bueno, pues sí.
All rise. The International Court of Justice is now in session. President Bernardo Sepúlveda and the Honorable Judges Lilian Oliva and Rafael Llano preside.
Buenas tardes, buenos días. Iniciaré mi intervención en español, nada más para darles a ustedes la bienvenida, para señalar también que el tribunal, la Corte, debidamente constituida, inicia este procedimiento en el denominado Case Concerning the Clarence Belt between the Kingdom of Aglovale versus the state of Ragnell. We start our proceedings with the applicant having the opportunity to present the views of the applicant. Please proceed.
With the permission of the court. Good morning, Mr. President, Your Excellencies, and esteemed agents of Ragnell. May it please the court. My name is Ana Mireya Ramirez, and today I'm here alongside my co-agent, Ricardo Lozano, and our of counsel, Emilia Silva, representing the Kingdom of Aglovale, acting as applicant in the present proceedings. In the following 22 minutes, I will present the first and second pleading in this case, concerning in the first place that Ragnell breached its treaty obligations in the launching of Operation Shining Star and its attacks on both the Nan Gateway and Comfort Arden, and that Ragnell must pay reparations to Aglovale for the death of 8 Aglovalian nationals who were killed on Compound Arden. Then we'll move on with the second pleading, regarding that Ragnell violated its treaty obligations by employing captured UAC fighters in the transportation of contaminated plastic waste and by detaining them in Camlan Correctional Center. In the following...
Discúlpeme usted que la interrumpa. Había yo solicitado en función del rebote que hay sonido, la acústica, que no es la ideal. Había yo solicitado unos audífonos que me los pudieran proporcionar. Disculpe usted la interrupción.
It's okay. Hola. Good morning, Your Excellencies. Is this better? Okay. Aquí? Should I restart? Thank you, Mr. President. I will begin again. Good morning, Mr. President, Your Excellencies, and STEAM agents of RECNEL. May it please the court. My name is Ana Mireya Ramirez, and today I'm here alongside my co-agent, Ricardo Lozano, and our of counsel, Emilia Silva, representing the Kingdom of Aglovale, acting as applicant in the present proceedings. In the following 22 minutes, I will present the first and second pleading in this case, concerning in the first place that RECNEL violated its treaty obligations by launching Operation Shining Star, the attack on Compound Arden, as well as the bombing of Nant Gateway, and that RECNEL must pay reparations to Aglovale for the death of 8 Aglovalian nationals who were killed in the attack on Compound Arden. Then, for the second pleading, we submit before this court that RECNEL violated its treaty obligations in the employment of UAC detainees, in the transportation of contaminated plastic waste, and by detaining them in Camden Correctional Center. In the following 21 minutes, my co-agent will present the third and fourth pleading, leaving 2 minutes for rebuttal. Your Excellencies, we understand that there is a concern regarding the admissibility of this first pleading. In this sense, we submit before this court that Aglovale complies with the monetary gold principle, given that the very subject matter of this case does not concern Bailen itself or does not generate obligations or rights to Bailen, rather than it is about the responsibility of RECNEL and the different breaches of the treaty that it has committed, and the subsequent declaration of this court that RECNEL has committed them and that it must comply with international law. In this sense, yes, Your Excellency.
Isn't the principle under monetary gold that there has to be prejudice suffered by the third-party state that is the essence, basically, of the case at issue? And here, it seems to me that the main prejudice of an invasion is the country that's being invaded. Isn't that right?
We submit before this court that in the rulings of the monetary gold, as well as in other rulings that this court has applied the monetary gold principle, such as certain phosphate lands in Nauru, between Nauru and Australia, this court has stated that it will only reject the possibility to resolve a certain claim when the very subject matter of said claim regards the third state that is not present in the court. In this sense, we're submitting before this court that as the resolution that it will conclude these procedures would only create responsibility, rights, and obligations to the state of RECNEL and not to the state of Bailen, that its presence does not constitute the very subject matter of this procedure. In this sense, I will move on with the first pleading, first stating the current situation in the belt and how this court should address it, then the different breaches of the treaty that RECNEL has committed, and in this sense, the principles of international law and international humanitarian law that are applicable, and I will finish with the reparation that RECNEL must pay to Aglovale for the death of 8 of its nationals. In this sense, this court should qualify the current conflict in the belt as an occupation pursuant to Article 42 of the Hague Conventions, given that the current presence of the belt complies with the two requirements set forth in said convention, which is the presence of a hostile army and the authority it exercises. In this sense, even though there is a lease that RECNEL was entitled to pursuant to Article 11 and 14, pursuant to Article 11 of the treaty, we must submit before this court that we're in a similar case than that of the legal consequences for stated in the continued presence of South Africa in Namibia, given that RECNEL has acted outside of the faculties and authorities that said lease was given to it. In this sense, I'm sorry, Your Excellency, do you have a question? Thank you. In this sense, we're submitting that the first requirement is fulfilled, given that RECNEL entered with its military forces, breaching Article 11 and 14 of the treaty, and then that it continues to exercise its authorities within the belt. Now, if I may refer this bench to Article 2 of the treaty, which each stated that the parties shall apply amongst themselves the provisions of the Charter of the United Nations and also of the international humanitarian law. I will begin with the different violations that Regnell has committed against the treaty. Now, regarding this Article 2, there is Regnell breached the... Yes, Your Excellency.
I just want to clarify the point regarding the occupation. Is your country asserting that, notwithstanding the fact that the respondent Ragnell withdrew his troops, it was still under effective Ragnellian control?
I'm sorry, Your Excellency, but can you rephrase your question?
Of course. Ragnellian troops withdrew at a certain point during year 2021. Are you asserting that Ragnell exercised effective control in the belt in the terms of the treaty, notwithstanding Ragnellian withdrawal of its troops?
Yes, Your Excellency. As it can be seen in paragraph 36 of the case, Ragnell continues to exercise its common authorities and faculties regarding its administrative and...
In terms of the treaty, of course, but as a factual, in terms of factual issues, we know from the agreed facts, Ragnell withdrew its troops. So I would like to know your country's position regarding the control of the troops vis-a-vis occupation and effective control.
I understand your concern, Your Excellency. So Ragnell continues to have presence of its military in the belt, and in this sense, it has forbade the original sovereign of said territory to exercise the faculties and authorities that grant effective control. In this sense, given that Baylan is not able to exercise effective control in its own territory, and the Ragnell is a hostile army which continues to exercise these faculties and authorities, is that we're submitting before the court that effectively occupation is actually actualized, and in this sense, all rules of humanitarian law are applicable pursuant to Article 2 of the Common Article 2 of the Geneva Conventions.
You stated that the occupation by a hostile army is met here because Ragnell was operating outside the scope, you said, outside the scope of the treaty. But the treaty, in fact, in Article 11(1)(c), says that Ragnell is entitled to maintain peace and order. Now, I see that it says through the deployment of police personnel, not military personnel, but maintaining peace and order, isn't that the point of the treaty? And if the other state is unable to provide peace and order, isn't it a faculty, an inherent faculty under the treaty to do what is necessary to maintain peace and order?
We're submitting before this court that this is not the case, given that the reason why it is stated in the treaty police personnel, it has historical reasons that can be seen in the statement of agreed facts.
Mm-hmm.
And furthermore, in Article 14 of the treaty, it states that during the duration of the lease, no military personnel can enter the belt. In this sense, given the whole context which the treaty was executed, the interpretation of military personnel in order to exercise, of police personnel in order to exercise the functions of keeping peace must be limited to police forces, not including its military.
And how is that context relevant in international law, and in particular with respect to the maintaining of peace and order that is explicitly in the treaty?
I understand your concern. Pursuant to the customary rules of interpretation of the treaty, which are contained in the Vienna Convention of the Law of Treaties, we must interpret the words first by their common mean, and then within the context of the treaty that has been within the context that they are celebrated. In this sense, the police personnel there is a reason why this treaty only contained provisions of police personnel, and furthermore at the militarization clause, given that in the context that this treaty was created, the presence of Ragnellian forces in the border of the current belt was what initiated, in a sense, the current war.
Thank you.
So in this sense, first we submit before this court that Ragnell has breached the general provision on the use of force. We understand that Ragnell is trying to claim that it is exercising its inherent right to self-defense. But first, we submit before this court that, as it has previously stated in cases such as armed activities in the Congo case and the military and paramilitary activities in and against Nicaragua, as well as the legality on the construction of a wall in occupied Palestine territory, that self-defense cannot be exercised against non-state actors unless it can be attributable to a state. In this sense, in recent years, the states have discussed if the inherent right of self-defense contained in Article 51 of the UN Charter, as well as in customary international law, applies to non-state agents. And countries such as Mexico and Brazil have stated that it cannot be applicable, given that it would be an extremely broader application of said article, and it could provoke the violation of the states to the rights of the sovereign rights of the other states. In this sense, we are submitting before this court that self-defense is not applicable. Now, as I previously stated, Article 2 of the Geneva Conventions states that in case of an occupation, all the rules of international humanitarian law are applicable. In this sense, regarding the attack on Compound Arden as well as on the Night Gateway, Ragnell violated two essential principles of international humanitarian law. First of all, the principle of proportionality, and second of all, the principle of precaution. The principle of proportionality, which is contained in Article 51 of the first additional protocol to the Geneva Convention, states that even if attack is allowed, it must not be excessive in relation to the expected military advantage. In this sense, it has been stated that a part of military advantage, in order to comply with the principle of proportionality, a military operation must seek the less injurious mean and proportionate means. In this sense, we're submitting before this court that by bombing the Nant Gateway, which was the only entry to the Tintigil Park and the only entry to the to the current belt, not only for Aglovale, but also for the civilians who were in the current belt, Ragnell did not take into consideration that by bombing it, the civilians could no longer escape the conflict, that they breached Article 15 of the treaty, depriving Aglovale of its inherent right to use, of its perpetual right to use the belt, and furthermore, that by bombing that belt, not only the civilians were trapped, but medical aid, food, and supplies were no longer able to reach the civilians that were there. These are rights that are contained in Article 23 and 55 of the Fourth Geneva Convention, as well as Article 7, Paragraph 2 of the First Additional Protocol. In this sense, yes, Mr. President.
For a second. According to the documents we have before us, it is said that the guerrilla forces, let's call them that way, were using the FAT in order to provide weapons by illegal means, utilizing that tunnel. What would you say about that? Would you not regard that as perhaps an act of self-defense in order to prevent the possibility of any more weapons entering through that tunnel into the territory controlled by Ragnell?
I understand your concern, Mr. President. However, we're bringing before this court that the principle of proportionality that is contained in the jus in bello, that should take into consideration any matter of self-defense or any military attack or target, should also consider the least injurious means. In this sense, Aglovale is submitting before this court that there were other means that could have attained the same objective than bombing the entrance of not only commerce, but humanitarian aid to the civilians. In this sense, Ragnell could have put additional police personnel or military personnel to guard the gateway instead of bombing it. In this sense, they could have controlled the entry of arms and other UAC members without breaching or forbidding any entrance of aid and the escape of civilians from the conflict. Now, regarding the principle of precaution,
Before you move on.
yes, Your Excellency.
Following up on Mr. President's question. So it seems to me that your country is asserting that there was no necessity met in the present case in terms of Article 25 of the draft articles of responsibility of states for international corporate acts. So what would be the right standard of necessity that Ragnel would have to meet?
We're talking about the whole Operation Shining Star,
Yes.
or are we referring
Yes,
to?
the whole operation, the bombing in particular.
Well, as we know, the concept of necessity that is contained in the draft articles of responsibility of the states is different from the necessity that is required in the jus ad bellum in order to carry out the exercise of the inherent right of self-defense. In this sense, we're submitting before this court that although from the beginning, self-defense cannot be exercised against non-state agents, even if it did not comply with the principles of necessity and proportionality, given that, first of all, necessity would have to be there cannot be other means of peaceful settlement of said disputes, and there were means possible that Ragnell has taken in order to address the dispute in the belt that were not the use of force, and that the proportionality is not complied, given that Ragnell entered with its full military personnel into the belt, while the UAC members were civilians with access to limited weapons and only makeshift bombs. So the proportionality in their response was not met. In this sense, and moving on with the attack on Compound Arden, Ragnell did not meet the requirements set forth in principle of precaution contained in Article 57 of the first additional protocol of the Geneva Conventions, given that their target verification was not correct, as they did not carry their proper due diligence, because they did not use all feasible means to carry out their obligations. Given that, first of all, the Valani informant has been historically claimed as inaccurate and misleading intelligence, and second of all, because the drone footage that they used in order to confirm the intelligence that the Valani informant used was previous to said intelligence. In this sense, Your Excellency, we're submitting before this court that with the advancements of technology and the full military power that Ragnell has, it could have conducted additional intelligence in order to assert that there were no civilians in the area.
And what is that additional intelligence? As I read it in the papers, there were drones that were flying overhead. There was this informant, and of course, mistakes are made during wartime. What is the standard? At a certain point, you can't walk into the compound, see who's there, and make a decision on perfect information. This is war. So what is the standard under international law to make such a determination?
I understand your concern, Your Excellency. However, as I previously stated, the drone footage that was used was previous to the intelligence received. And knowing that they have deprived the civilians the possibility of entering the conflict by bombing the Nantes gateway, they should have taken additional precautions. Furthermore, the principle of precautions gives the opportunity to a state to have an advance warning in their attacks in order to civilians to be able to escape the bombing. So if they had given this advance warning and complied with the principle of precaution, no civilians would have been killed. In this sense, for the internationally wrongful acts that Ragnell has committed, we're submitting before this court that Ragnell is owed compensation. Now, moving on with the second pleading, we're submitting before this court that Ragnell has breached the rights of the UAC detainees that should be qualified as prisoners of war, regarding their employment in healthy and dangerous work.
I would like to interrupt you there, Agent, because from the facts of the case, we're aware that most of the UAC members are Balan nationals. I'm sorry. So I would like you to clarify if you are bringing a claim on behalf of foreign nationals.
We're bringing this claim not from the perspective of the Baliani members, but for the obligations that Ragnell breached under the Third Geneva Convention. As Your Excellencies can see in Article 1 of the Common Article 1 of the Geneva Conventions, it is stated that all the states that are parties of said convention have the obligation to watch out for its compliance. In this sense, as I'm continuing with Article 2 of the treaty, which states that all parties are subject to the compliance with international humanitarian law, we're bringing this claim in an erga omnes partes basis.
Okay, so if this court were to grant, to provide for damages to be paid to the affected Balearic nationals, how would your country would provide them to those foreign nationals? I mean, or would the applicant keep damages for itself if it's not acting on behalf of foreign nationals? I really don't see the standing of your claim.
Regarding the present pleading, we're not submitting that we are entitled to the compensation owed to the Balinese UAC members which were wrongfully employed in the transport of hazardous waste, but we're submitting that RIGNEL should cease its internationally wrongful act of employing them that they should uh, pay satisfaction recognizing that they wrongfully employed them, and furthermore, that by transferring them, they were committing internationally wrongful acts, and in this sense that they should return the Balinese detainees to the belt.
Right, but if your state is espousing claims on behalf of individuals, have domestic remedies been exhausted?
As they are prisoners of war, there and no.
No,
They-
I'm referring to presumably the families of the dead individuals at the NAND gateway, for example.
Okay. Yes, actually, local remedies have been exhausted. And regarding the specific death of the 8 nationals in the NAT gateway, we're actually bringing this claim to their protection, as it can be seen in clarification 2 of the Statement of Agreed Facts.
Thank you.
Now, just to state the different violations of international humanitarian law that RIGNEL has committed in their employment, it has been stated that although RIGNEL is trying to state that they that they employ these prisoners of war because of public utility basis, we're submitting before this court the special rule that should apply is Article 52 of the Third Geneva Conventions, because they were employed in unhealthy work and their character of their employment was not voluntary. Now, the character of voluntary is an essential requirement of said article, and the nature of the work is that should be ascertained. Now, regarding the transfer, it is stated in Article 46 of the Third Geneva Convention that it is in the interest from the self, and they should not have to be increasing of the need of a repatriation. In this sense, by transferring them outside of the belt, RIGNEL has created the need of the repatriation, so they breach this principle. For these reasons, we submit before this court to adjourn and declare in our favor. Thank you, Your Excellencies.
Thank you. Thank you very much indeed.
Agents of the applicant and of the respondent, we're going to have a break in order to solve some difficulties that we're having regarding the audio. We're going to be resuming the round in a few minutes. Thank you very much. Please remain seated, and to the observers, please also remain in the courtroom. We're going to be restarting very, very soon.
¿Me escucha?
Perfectamente, sí, muchas gracias.
Hola.
Sorry for this delay, and so when the president is ready, we're going to resume the round. Thank you.
Please proceed.
With the permission of the court, Mr. President, Your Excellencies, agents representing the state of Ragnall, good morning. May it please the court. My name is Ricardo Lozano, and it is an honor to appear before this court, this notable court, pleading on behalf of the applicant in this proceeding, the Kingdom of Aglovale. As my co-agent already referred, I will be speaking for the next 21 minutes, during which I'll be addressing Aglovale's third and fourth pleading. The third one referring to the lawfulness of the economic sanctions imposed by the Kingdom of Aglovale and how there is no obligation to withdraw them or to compensate the state of Ragnall. And the fourth one referring to Ragnall's breach of its treaty obligations by transporting hazardous plastic waste to the state of Etna, and how, on the other hand, the Kingdom of Aglovale complied with its treaty obligations by refusing to cooperate in the management of this waste. Now, to begin with our third pleading, we would like to note that there is not uniform state practice or opinio juris to affirm that economic sanctions by themselves are unlawful in nature. This is evidenced by the issue of the General Assembly resolutions, specifically Resolution 2107 regarding Portuguese territories, Resolution 2383 regarding Southern Rhodesia's right to self-determination, and Resolution 42209 regarding occupation of Palestinian territories by the State of Israel. It is also true that the General Assembly has also issued resolutions in which it has advised states to refrain from the imposition of unilateral economic sanction, but this just further proves the fact that there is not uniform state practice or opinio juris that qualifies economic sanctions by themselves as unlawful. In this sense, economic sanctions can be lawful as long as they comply with international law provisions, which we did in this case, as the economic sanctions imposed by the Kingdom of Aglovale complied with the principle of non-intervention and with international trade law. Firstly, the economic sanctions imposed by the Kingdom of Aglovale complied with the principle of non-intervention, as Ragnell's Domegesegve was not hindered in this case. This is stated due to the fact that this court, in the case concerning the Barcelona traction, specifically in paragraph 33, determined that the Domegesegve of a state cannot govern the violation of human rights in a determined case. And considering that the economic sanctions were imposed by the Kingdom of Aglovale as a result of human rights violations in the Clarence Belt area, then the state of Ragnall cannot assert that the hindering of their Domegesegve was met in this case.
Can you explain again the relevance of Barcelona traction to this case? I'm trying to match the two. I'm not seeing it, but can you try again, please?
Of course, Your Excellency. In the Barcelona traction case, this court determined that human rights cannot, the compliance with human rights law corresponds to the entirety of the international community. And every state in the international community has a legal interest to enforce that human rights law is respected in every case. In this sense, as the economic sanctions were imposed to the state of Ragnall, due to the fact that they violated human rights law in the Clarence Belt area.
But again, Barcelona traction was not about human rights.
No, it was not, Your
Right.
Excellency.
This was a case about protecting the interests of foreign companies within the state. And again, I'm trying to understand the relevance to humanitarian law and protection of human rights.
Well, it was determined in that case, Your Excellency, that the rights of people and it studied numerous rights, including the rights of the company, of the Belgian investors on the company, and specifically in the point where it studied the rights of Belgian investors in the company, this court determined that the human rights law has to be respected by the entirety of the international community, and that every state in the international community has a legal interest to ensure the respect of the human rights regime. In this sense, as the economic sanctions were imposed as a response to human rights violations in the current belt area, the state of Ragnall cannot assert that the Megasec B was hindered in this case.
So the economic sanctions were countermeasures, as far as I understand. What would be the legal concept under international law for countermeasures, and what would be the standard for the legality, if so, of those countermeasures?
Of course, Your Excellency, countermeasures are a response to an internationally wrongful act committed by another state. It may not be lawful per se. However, it has to fulfill certain requirements that are put forth by the draft articles on the responsibility of states for internationally wrongful acts. First, they have to be imposed as a response to an internationally wrongful act. They have to be proportional. They have to respect fundamental human rights, and they have to comply with certain procedural requirements, one of them being the notification of the countermeasure. I hope that answers your question, Your Excellency.
I might as well intervene now to ask a similar question, and that has to do to your assessment as to whether the state imposing sanctions thought that its essential security interests were being affected. Would you say that really those essential security interests were being affected by the activities of Ragnell?
Well,
And if you allow me also, would you say that you have the capacity to determine the question of essential security interests being affected, or is there any other entity that should sanction the validity of these countermeasures?
Well, thank you for your question, Mr. President. We actually contend that we are imposing the economic sanctions as the security interests of Agloville were compromised in this case. That is specifically referring to our argument referring to international trade law provisions. Yes, we do esteem that the International Court of Justice is competent to know of the arguments referring to international trade law, as we had a right of forum shopping that has been a concept that has been elaborated by doctrine, in which referring to a claim brought forth by an international tribunal in the case where there are many arguments relating to many different subjects, as is the case due to the fact that we are bringing forth violations of international humanitarian law, human rights law, and international trade law, that we can bring forth the claim before the tribunal that is competent to know of these matters. If we brought the claim before the panels of the World Trade Organization concerning the interpretation of the security interest exception, they would not be able to rule over the other arguments that we are bringing forth before this court regarding to international humanitarian law and human rights law. And that is why we esteem that this is the competent court to know of this matter, as this is a complex case and it can rule over different matters in this case, Mr. President. I hope that answers your question.
Thank you.
Now, moving on, we also contend that the economic sanctions were compliant with international trade law, as the security interest exception contemplated in Article 21B, paragraph 3 of the General Agreement on Tariffs and Trade was triggered in this case. This article establishes that when the security interests of a determined state are threatened by international emergency or by war, then that state may be able to not comply with certain provisions of the General Agreement. This is important due to the fact that under the Trilateral Treaty for Lasting Peace, there was an obligation to promote free trade and economic advancement according to the applicable principles of international law that govern those principles.
Mr. Agent, you say that the sanctions were compliant with international law generally, but now you've made a specific reference to the treaty. So let's talk about the treaty.
Yes, Your
Now,
Excellency.
the treaty contains specific authorities that your state would have within this zone, including to abide by the principles of neutrality, and also to document any and record and investigate any complaints of infringements. It doesn't say anything about sanctions. And your colleague made a point about acting outside the scope of the treaty. Now, are these sanctions not also outside the scope of the treaty?
Your Excellency, we would not contend that these sanctions are outside of the scope of the treaty. All of but instruments of international law that I have been referring are due to the fact that on Article 2 of the Trilateral Treaty for Lasting Peace, on paragraphs 1 and on paragraph 3, the treaty itself refers to rules that are contained on other bodies of international law.
Yes, but it also contains these specific provisions and authorities. So my question again is there a theory under international law that you're relying on to say that you're excused from these specific areas of action that you have under the treaty in order to also impose sanctions? Can you get out of the treaty, in other words?
Yes, we could, well, not exactly get out of the treaty, but if you're referring to a specific principles that we are applying in order to impose the economic sanctions that may fall outside the treaty, we are basing the imposition of the sanctions on the international law principles of jurisdiction, specifically the subjective territoriality principle of jurisdiction and active nationality principle of jurisdiction, Your Excellency.
Has this court ever decided that a given country has violated a treaty related to economic advancement due to unilateral sanctions, economic sanctions in general? Is there any precedent?
No, I cannot recall an exact precedent of economic advancement. However, this court has studied economical sanctions in many cases. For example, the case concerning military and paramilitary activities in and against Nicaragua, in which it determined that the economical sanctions that were being imposed by the United States of America were not violatory of the principle of non-intervention in that specific case. It has also been studied in the case concerning oil platforms between Iran and the United States of America, but I cannot recall an exact case where the economic advancement principle was studied, Your Excellency. Now, that same article that I was referring to, 21B paragraph 3, states that countries enjoy a margin of discretion for the application of the security interest exception, which is only limited by the principle of good faith. In this sense, considering that we are in front of a case of occupation, which is an international emergency, according to the interpretation of that concept by the World Trade Organization, and that the economic sanctions were imposed in good faith by the Kingdom of Aglovale, then the security interest exception can be considered as triggered in this case, and thus the economic sanctions can be considered as compliant with international law. If there are no further questions regarding our third pleading, we would like to move on to our fourth pleading, in which we contend that Ragnall violated its treaty obligations by transporting hazardous plastic waste.
I'm sorry, I'm just one quick question on the last point. So
Yes, Your Excellency.
on the security exception, right?
Yes.
What is the security concern on the part of Aglovale to trigger these sanctions?
Well, according to the article 21B paragraph 3, the security interest exception can be invoked when there is an international emergency. And according to the interpretation of that concept by the World Trade Organization, it can be considered as an emergency in international relations where it appears that there is a situation of armed conflict or heightened tension of crisis due to general instability engulfing or surrounding a state.
Right. So your interpretation of that provision is that it doesn't require a conflict, a direct conflict between the two states, a war, for example, between the two states.
Yes. Well, according to the interpretation given to that concept by the World Trade Organization, there does not need to be a direct armed conflict between Ragnall and the Kingdom of Aglovale. And we are applying it by reason of the attack on Nant Gateway and the attack on Compound Arden, which resulted in the death of 8 Aglovalian nationals as a result of an armed conflict that was being carried out in the Clement Belt, and the attack on Nant Gateway, which restricted our commercial passageway and isolated Aglovalian nationals in an armed conflict zone without access to basic necessities such as food and water or humanitarian aid. If there are no further questions regarding our third pleading, we would move on to our fourth pleading. Agloville also complied with, we will also contend that Agloville complied with the treaty as there was not an express obligation to cooperate in the management of the waste. Now, regarding the first part of this argument, the failure of Ragnell to ensure that the hazardous waste would be managed in an environmentally sound manner by the state of Edna resulted in the violation of Article 28 of the treaty, due to the fact that this omission resulted in the damage of the health and the environment of the Gais Peninsula and its surroundings. This principle of environmentally sound management of waste is specifically contained on the Basel Convention. And this principle will be applicable in this case as do in Article 11 of the Basel Convention when two countries or more countries celebrate an agreement on the transport of hazardous waste, then that agreement may not contain provisions that are less environmentally sound than those contained in the Basel Convention. In this sense, Ragnell was obligated to respect the principle of environmentally sound management of waste as was regulated on the Basel Convention. And this principle is contained on Article 4.2e of the Basel Convention, which states that when there is reasonable doubt as to the management of hazardous waste by another state, then the first state should halt the export of hazardous waste to the state where there is reasonable doubt as to the management of hazardous waste.
Question on that point, Agent. If neither of the parties to this case is a party to the Basel Convention, how is the court to apply the principles contained therein?
Well, Your Excellency, as Edna and Ragnell, well, Edna is a party to these conventions. However, Ragnell is not. But the principles will be applicable due to the fact that Ragnell concluded an agreement with Edna under Article 11 of the Basel Convention. By doing this, the agreement that Edna and Ragnell celebrated could not contain provisions that were less environmentally sound than all of the provisions contained on the Basel Convention. And as the principle of environmentally sound manner is regulated in a specific way in the Basel Convention, and that should be considered as the environmentally sound manner of that provision, then Ragnell was obligated to respect the principle as is regulated on the Basel Convention. I hope that answers your question.
Following on this same issue, wouldn't you say that Ragnell was duty-bound to move this waste for humanitarian reasons also? Because according to what we have been learning, the damage that could be done if that waste remained in the belt, in the area, would be tremendous, and human beings would suffer a great deal if that waste was not somehow disposed of. And that is why, according to Ragnell, there was an imperative reason to move the waste somewhere else. What would you say to that?
I understand your concerns, Mr. President, and we in no form are contending that Ragnell shouldn't have transported the hazardous waste to another state that could process the waste in an environmentally sound manner. However, by transporting the hazardous waste to the state of Etna, Ragnell failed to comply with the principle of environmentally sound management of waste.
Yeah, but of course, that other state that was readily available was your state, wasn't it?
It was, Your Excellency.
Right? And why didn't you take it?
Well, due to the fact that under Article 28 of the Trilateral Treaty for Lasting Peace, cooperation between the parties on environmental matters was not unlimited, Your Excellency. It was subject to reasonable or necessary requests. And the requests made by Ragnell were neither reasonable nor necessary.
But that sounds inconsistent. You're saying that Ragnell was required to transport waste to a country that was willing to take it and that was compliant with international standards. One such state, your state, refused to take it. And now you're complaining to this court that Ragnell transported the waste to a different country. So how do you square that?
Well, I repeat, I understand it may seem inconsistent, Your Excellency. However, the fact that Edna was readily available to receive the hazardous waste by the state of Ragnall does not mean that Aetna had the equipment or the plans to process waste in an environmentally sound manner. And the fact that Aetna was a party to the Basel Convention and the Stockholm Convention also does not make that state capable of managing the waste in an environmentally sound manner. We contend that we also contend that we did not have an obligation to cooperate due to the fact that the requests made by Ragnell were neither reasonable nor necessary. They did not take into account the rights and liberties of Agloville as they conducted indiscriminate operations on NAND Gateway and Compound Iron, which resulted in the death of 8 of our nationals and which restricted, as I already mentioned, the main commercial passageway used by Agloville, the access to the interior port, and they isolated Agloville nationals in an armed conflict zone.
Are you saying, and is this supported by the facts that Agloville did not accept the waste as a sanction because of the attack on NAND Gateway? Because you seem to be making that connection.
In no way we're referring to that, Your Excellency. It is only that right now the Kingdom of Agloville was not obligated to cooperate as the respondent is alleging, due to the fact that the obligation to cooperate under the treaty was not unconditional. And the requirements that needed to be fulfilled by the respondent were not fulfilled. The requests were not in no way reasonable, and they were neither necessary as well, due to the fact that if we interpret the term as necessary as a circumstance precluding the wrongfulness of acts, the plant that was in Ragnall got destroyed due to the fact that it was carrying out an armed conflict between UAC fighters and Ragnall. And by that reason, it can be stated that Ragnall gave rise to the state of necessity that resulted in the destruction of the plant.
Yeah, but if there was a state of necessity, by definition, there was a necessity. It became necessary to dispose of the waste somewhere. So you're saying it wasn't the requests that were made to Agloville did not satisfy the necessity requirement. They were not necessary, and yet you're complaining that they were transported to a different state, and that it was necessary to find the right state to take that waste. So that necessity aspect of your argument is the one that I'm having a little bit of trouble with.
Your Excellency, my time already ran out. I don't know if I can have an additional 30 seconds or a minute.
Up to the president.
Yes, you may.
Well, Your Excellency, the necessity aspect of the cooperation, we indeed contend that it was not met. However, we are not imposing an impossible condition to the state of Ragnall. From the statement of agreed facts, specifically paragraph 56, it can be seen that Ragnall had many commercial relationships that remained intact. Some of them may not have been developing countries, which are forbidden to manage waste in an environmentally sound manner by the Basel Convention. In this sense, Ragnall had many options and was not obligated by a state of necessity to cooperate with the Kingdom of Agloville. In this sense, we respectfully request this court to rule in our favor. May it please the court.
Thank you. Could I ask the respondent to start submitting claims or counterclaims? Thank you.
Mr. President, Your Excellencies, may it please the court. My name is Jose Emilio Garcia, and along with my co-agent, Ms. Mariana Campos, my of-counsel, Ms. Mariana Rivas, and our team members, Ms. Paulina Regil and Mr. Hector Bernal, we are honored to appear before the International Court of Justice in representation of the state of Ragnall, the respondent in the present case. I will speak for 22 minutes, and in the best interest of order, because of the relation of the pleadings, I will cover issues A and C. Regarding first, whether Ragnall complied with its treaty obligations by deploying Operation Shining Star in the attacks of the NAND Gateway and the Compound Iron. And second, whether Agloville violated its treaty obligations by imposing unilateral sanctions to Ragnall. My co-agent will speak second for another 21 minutes, and she will cover issues B and D, regarding first, whether Ragnell complied with its treaty obligations by employing the UAC detainees and transferring them to the Camlan Correctional Center, and second, whether Aglobel violated its treaty obligations by refusing to cooperate in the treatment of the waste, and that Ragnell complied with its obligations by sending this waste to Etna. We respectfully leave 2 minutes for the rebuttal. Your Excellencies, before this agent starts with the pleading aid, it must be solved the question of admissibility in the present claim. In accordance to what the applicant mentioned, the monetary principle cannot be applied to the claims concerning the pleading aid, since Balan is not an indispensable party to the present dispute. But Your Excellencies, according to according to clarification 3 of the statement of accurate facts, Balan took action in some of the attacks that were concerning the territory of the belt, such as in the Nantes Gateway. Balan had its troops in the gateway by the moment of the attack, and also it was notified about the operation. Also, Your Excellencies, if this court determines something about the matter of the occupation that the applicant is claiming, it would affect actually the juridic interest of Balan, since it is its territory and its juridic status concerns to this state. This is why, Your Excellency, in the present case, the respondent contends that actually the monetary gold principle shall be applied to the present dispute, since Balan is an indispensable party to the dispute, and any judgment concerning to this matter could affect this third party.
Can I ask you the reverse side of the question that I asked to your opponents, which is on the monetary gold principle? So the damages that are being asked in this case from this court relate to damages suffered directly, presumably, by Aglobel, and in particular to its own citizens. Now, how does the declaration that the war was unlawful under international law require Balan to be present in these proceedings, as opposed to damages?
Well, concerning to the damages, Your Excellency, it is the content of the respondent that in the present case, the attack of the Nantes Gateway also has involvement of Balan in that case. Therefore, it could have responsibility if any declaration concerning to the illegality of that attack.
Yeah, but the treaty is among 3 parties, isn't it?
Yes.
So a violation of the treaty, doesn't a violation of the treaty trigger responsibility vis-a-vis either of the other 2 states?
Of course, Your Excellency. But it is the content of the respondent that in the present case, any judgment concerning to this matter actually could affect Balan, but this does not preclude the fact that Aglobel could claim on its responsibility and on its rights concerning to its national and its territory, since a juridic matter concerning to its territory will be judged by this claim. This is why, Your Excellency, in the present case, the respondent contend that the claim shall not be considered admissible. Nevertheless, even if this court considered that the claims concerning the pleading aid are admissible, here's the content of the respondent, contrary to what the applicant mentioned, that Ragnell is not making occupation in the territory of the Clarence Belt by deploying Operation Shining Star. Your Excellencies, in accordance with to what the court established in the armed activities in the Congo and also in the Palestinian Wall advisory opinion, it was issued by this court that in order to have an occupation, 2 elements must be fulfilled. The first one is the presence of a hostile army in the territory, and the second one is the substitution of the authority of the sovereign power in the territory. Your Excellencies, in the present case, there is no substitution of the authority of Balan over the territory of the belt. In accordance with Article 11 of the Trilateral Treaty of Lasting Peace, the functions that supposedly the applicant is claiming that were a substitute from the Balan concerning to the obligation to preserve the peace and order in the belt are not substituted, since under Article 11, there is an obligation of Ragnell to preserve the peace and order in the Clarence Belt. Now, Your Excellencies, therefore, there is no occupation. And also, contrary to what the applicant mentioned, the right of self-defense can be effectively exercised in the present case, since all the elements are fulfilled. The applicant only mentioned that self-defense cannot be exercised against non-state actors. Nevertheless, Your Excellencies, in accordance to recent state practice, States agree that self-defense could be actually exercised against non-state actors. This happens after the events concerning the 9/11 and Resolution 1373 of the Security Council. But Your Excellencies, also in dissenting opinions, such as in the advisory opinion of the Palestinian Wall, Judge Higgins and George Borgendahl established that self-defense actually shall be exercised against non-state actors. Also, Your Excellencies, there are cases such as in the Institute of the African Union that it does not prohibit, it actually permits the state to use self-defense against non-state actors.
On that point, Agent, I'm sorry to interrupt you. What would be the standard, the minimum standard of state practice in order to consider that the international community would accept a right of self-defense regarding armed groups
Okay, Your Excellency,
or
concerning
terrorist groups?
are you referring to custom on the exercise against non-state actors?
State practice as an element of the custom.
Okay, Your Excellency, concerning that point, it is the content of the respondent that even if there is no enough state practice concerning to this, but it actually exists as previously established. There is no specific provision under Article 51 of the UN Charter in order not to use self-defense against non-state actors. Actually, the elements of self-defense were complied in the present case, since there was an injury of an armed attack. Also, yes?
Sorry, don't you think that Article 51 of the UN Charter has been consistently interpreted so as to understand a conflict between two states, the use of the right of self-defense regarding states, not non-state actors?
Yes, Your Excellency, but in accordance to recent practice, such as in the 9/11, which is a more clear practice, when the non-state actors get a force in order to attack and injure a state in a such manner that a state actor could do, it could be considered that self-defense can be exercised against non-state actors.
Isn't that true, except when the non-state actors are somehow related or linked to state activity? In other words, the 9/11 example was that Afghanistan was providing safe haven to terrorists, and therefore Afghanistan implicitly was part of the attack. And that's what justified the UN action in the resolution that you mentioned. I want to understand the facts of that resolution and how they link up to the case at hand.
Perhaps following the questions made by my two colleagues, it may be useful to know your views also on the basic definition of self-defense. By that I mean the Caroline case, which indicates self-defense takes place when it's imminent and there is no choice of means and no moment for deliberation. That's what was indicated in the Caroline case. I don't see the imminence, and I don't see also the other choices of means according to the classic definition of self-defense. What would you say about that?
Of course, Your Excellency. Concerning to the first question, Your Excellency, of the resolution of the 9/11 or Resolution 1373, it was established that the terrorist group were linked with the state, which is not the case in the present case. Nevertheless, it was issued that there is a possibility to use self-defense against non-state actors. This is why, Your Excellency, the respondent is contending this. Concerning to the second question, Your Excellency, self-defense must be, that's true, the last resource or the last meaning in order to be exercised. And this is why, Your Excellency, in accordance with what this court established in the oil platforms case and also in the armed activities in the Congo, the measure that was taken was the last resource that Ragnell could take. In accordance with paragraphs 26 and 27 of the Statement of Accurate Facts, Ragnell repeatedly, in the repeated occasions, asked for help to Belen and Aglovale in order to refrain the UAC fighters' attacks that consisted in 3 years of raids. More than 200 attacks were committed by the UAC fighters against Ragnellians and Ragnellian companies. This is why, Your Excellency, Ragnell took as a last resource the Operation Shining Star in order to exercise self-defense. Now, Your Excellency, also, in accordance with the case of all platforms, this self-action measure shall be proportional. In the present case, it is the content of the respondent that it was proportional since the use of force of the UAC fighters were in accordance or commensurate with the military force that is used by the state in order to refrain the attacks. This is why, Your Excellency, Operation Shining Star is a legal exercise of the right of self-defense. Moving on.
Before closing this word,
Yes.
agents, just following up on the Article 51 of the UN Charter. So is your country asserting somehow alleging that there is the necessity to interpret in an evolutive manner such an article? And what would be the standard to depart from a consistent interpretation of Article 51 regarding the right to self-defense?
Regarding to the consistent interpretation in cases such as in the advisory opinion of nuclear weapons, also in the armed activities in the Congo, oil platforms, and the Nicaragua judgment, the element of necessity and proportionality has been interpreted in a case-by-case basis. In the present case, it must be analyzed at the facts that were occurred concerning to this.
Sorry,
Yes.
perhaps I didn't make myself clear. I'm not addressing the question of the standards for self-defense to be legitimate, but rather the parties that can exercise such a right. So you use Article 51 of the UN Charter to assert your country's right to exercise self-defense regarding an non-state actor. So I'm asking you whether if you are asserting evolutive interpretation of Article 51, how would you assert a right on behalf of the country for such an interpretation? What's your basis? Any precedents, relevant precedents of such an interpretation?
Of course, Your Excellency, evaluative interpretation of the right of self-defense has been issued by the state in order to exercise the right of self-defense against non-state actors. This was used and issued by France by deploying Operation Manta in Chad also, Your Excellency. Therefore, it is the reason that the respondent contend that in the present case, this evaluative interpretation could be exercised by the respondent. But moving on with the second part of this first pleading concerning to the attacks of the NAND Gateway and the Componarden. Concerning first the attack of the NAND Gateway, the applicant mentioned that it was not proportional since it caused harm to the civilian population that were inside of the territory of the belt. But Your Excellencies, in accordance with the statement of agreed facts and its clarification too, it was established that Balan evacuated the civilians from the territory of the belt, and it in this operation least for 2 days, from the 20 December to December 22 of 2021. The attack of the NAND Gateway occurred on December 23. This is why, Your Excellency, no civilians were harmed in the operation concerning to the NAND Gateway, since no civilians were inside of the territory of the belt, and also since there was actually a military advantage from taking this. The UAC fighters were using the NAND Gateway as a military mean of communication in order to introduce weapons, reinforcements, and to launch a surprise attack against the Ragnellian forces. This is why, Your Excellency, since there was no harm to civilians, and since it complied with the element of having a military advantage under Article 52, Paragraph 2 of the Additional Protocol 1 to the Geneva Convention, this attack was in accordance with the rules of international humanitarian law. Concerning to the second attack of the Componarden, the applicant mentioned that the principle of precaution was not complied, since the Ragnell did not took the feasible and adequate measures in order to comply with the principle of precaution. But Your Excellencies, in accordance with the Kopreskich case under the ICTY and with the NATO bombing, the final report to the prosecutor concerning to the NATO bombing, it was established that in order to comply with this principle, it shall be taken into account the circumstances of the moment of the attack. Since all the civilians by the moment of the attack were evacuated from the territory of the Clarence Belt, there was no reason to believe that civilians could be around the military objective. This is why, Your Excellency, the threshold concerning to the compliance of the principle of precaution was complied in the present case, since in accordance with the Kopretsky's case and also with the NATO bombing, this threshold is lower than a normal situation in which civilians could be in the territory. This is why, Your Excellency, in the present case, the respondent contends that both attacks of the NAND Gateway and the Copenhagen were in accordance with the rules of international humanitarian law. Moving on to the pleading C, Your Excellency, it was the reason, in accordance to what the applicant mentioned, that the actions described on pleading A were the reason of the sanctions imposed to the state of Ragnell. The applicant
Civilians did die in the attack on the compound, right?
Yes, Your Excellency.
So civilians did not die. You made that distinction. Civilians did not die in the NAND Gateway. They did die in the compound, which was the second attack, right?
Yes, Your Excellency.
So wouldn't assuming, taking your word that the attack on the NAND Gateway was in accordance with international law, and I'm not accepting that proposition, I'm just suggesting it for the moment, wouldn't that be the standard of due diligence that you should have exercised for the second attack in terms of giving prior notice, protecting civilians, doing your due diligence effectively?
Of course, Your Excellency, concerning to that point, the protection of civilians had a lower threshold in order to comply with this obligation, since there was no belief of civilians in the territory of the belt because of the evacuations of Balan in the belt. Now, Your Excellency, in accordance with the Kopretsky's case and with the NATO
But
bombing,
the evacuation was precluded by the attack on the NAND Gateway. That's the whole reason why there were civilians still at the compound.
Your Excellency, allow this agent to disagree, since the evacuation of civilians in the humanitarian corridor had a duration of 2 days, and the humanitarian corridor started in December 20 and entered in December 22. The launch of the attacks were after those dates. This is why, Your Excellency, no civilians were believed that could be harmed in the attacks. Now, Your Excellency, moving on with the pleading C, the applicant mentioned that the sanctions were imposed to Ragnell because of their international wrongful acts in the territory of the belt. It also mentioned that these sanctions are legal under international law, since they does not violate any rule of international law. And it mentioned the principle of non-intervention. But, Your Excellencies, the applicant failed to prove that in the present case, the elements in order to violate non-intervention were complied. In accordance with the Nicaragua judgment case on its paragraphs 205 and 207, in order to violate the principle of non-intervention, 2 elements must be fulfilled. The first one is the coercion, and the second one is the affectation of the internal affairs of the state. In accordance with Resolution 1524 of the Human Rights Committee, sanctions by its own nature are coercive, and since there is a measure exercising pressure against Ragnell to change its conduct in the territory of the belt, it must be defined that there was coercion. And the second element, Your Excellencies, the affectation of the internal affairs, was also complied, since Aglovale, by imposing the sanctions, did mess with the central bank of the state of Ragnell. Your Excellencies, the central bank is the principal organ of the economy of the states, and the most important concerning to taking the decisions. And therefore, there is a violation to the principle of non-intervention, since there was coercion by imposing the sanctions, and also there was messing with the central bank of the state, and therefore with the internal affairs.
But Agent, isn't it true that many of the most serious effects on the economy of your country were caused by third-party actors also adding to their own sanctions, basically, on top of the sanctions imposed by Aglovale? So my question is, can you separate the effects in terms of coercion? That's part of your standard. In terms of coercion, how much of the coercion was placed upon your state by Aglovale and how much by these other third-party actors?
Your Excellency, concerning that point, it was all the coercion exercised by Aglovale by imposing these sanctions, since all the bank accounts that were freezed of the central bank of Ragnell were in the territory of Aglovale. Therefore, there is a causal nexus between the imposition of the sanctions and the effect that it took in the economy of Ragnell. This is why, Your Excellency, in accordance with the Bosnian genocide case and with the armed activities in the Congo, since there is a causal nexus between the international wrongful act of Aglovale and the situation that Ragnell is living concerning to its economy and to its health system that was damaged because of the sanctions.
Can you compare the facts of the Congo case to this case?
Of course, Your Excellency. The facts of the Congo case are that Uganda were in effective control of some of strategical points inside of the Democratic Republic of the Congo. And it was issued by the court that there was actually an occupation since there was substitution of the authority of the Democratic Republic of the Congo. In the present case, it is different since there is no substitution. But, Your Excellencies, the matter concerning occupation has arisen by the applicant, therefore, it's the only relation. I'm afraid that my time is over, Your Excellencies, so thank you. I leave the floor to my co-agent. May it please the court.
Thank you. Thank you very much indeed.
Mr. President, Your Excellencies, may it please the court. Good morning, Your Excellencies. My name is Mariana Campos, and it is an honor to appear before the International Court of Justice in representation of the state of Ragnell, the respondent in the present case. I will speak now for 21 minutes, and I will cover issues B and D, regarding first, whether Ragnell complied with its treaty obligations by employing the UAC fighters in the transportation of the waste, and whether Ragnell complied with its treaty obligations by transferring them to Calam Correctional Center. Second, whether Ragnell complied with its treaty obligations by exporting the waste to Edna, whereas Aglovale was the one that uncomplied with the treaty by conditioning the treatment of the waste. Regarding pleading B, Your Excellencies, this agency has two main submissions. First, that Ragnell complied with its treaty obligations by employing the UAC fighters in the employment of the UAC fighters. And second, that Ragnell complied with its treaty obligations by transferring them to Calam Correctional Center. In respect of the first submission, we contend that regarding admissibility, the applicant failed to establish that the clarification number 5 is regarding the nationals of the compound Arden and the non-gateway, know about the UAC fighters. So Aglovale has not exhausted local remedies. If this court determines that there is admissibility under this claim, we contend that Ragnell complied with the relevant provisions of humanitarian international law. As in this case, we are in an international armed conflict.
Agent, I'm sorry to interrupt. You just affirmed that Aglovale would have had to exhaust local remedies regarding Balang nationals. How would that be the case? Are you asserting that Aglovale should have exercised diplomatic protection on behalf of Balani nationals?
Your Excellency, in accordance with Article 34 of the Statute of this court can only judge states. And even though if the applicant will invoke diplomatic protection, the two requirements to be met in order to be applicable will not be complied by the applicant state, since these two requirements are to be national of that state and second, to exhaust the local remedies. In the present case, as none of these requirements are met by the applicant will not have admissibility under this claim, under this figure.
To which local remedies were you referring to instead? When you just affirmed that Aglovale, before coming before this court, should have exhausted local remedies. What remedies were you referring to?
Your Excellencies, in order to appear before an international court, the states have to exhaust the local remedies in its national jurisdiction. In the present case, as in the applicant has not exhausted the local remedies in its national jurisdiction, it may not have the admissibility to claim the submissions that it claimed in its submissions.
I shall refrain my question to which claims in particular are you referring to that needed the previous exhaustion of local remedies?
Regarding the UAC fighters that the applicant stated that Ragnell violated.
Palani nationals, then.
Balani nationals, Your Excellency. Your-
But as a follow-up to Justice Oliva's question, you're talking about espousal arguments and general international law and exhaustion of remedies, which is, I understand, but there's also a treaty here, right? Doesn't the treaty give this court jurisdiction, and are the claims not admissible under the treaty, given if the argument is that there was a violation of the terms of the treaty in the treatment of these individuals beyond general principles of international law?
In the alternative, Your Excellency, we submit that if this court considers that the claims of the applicant are admissible, we contend that in accordance with the international rules regarding international armed conflicts, Ragnell complied with these provisions, since the applicant stated that Ragnell violated Article 52 of the Third Geneva Convention, which establishes that unless he be a volunteer, no prisoner of war shall be employed on a dangerous or unhealthy labor. But the key factor, Your Excellencies, in this present rule is the consent of the prisoner of war. In the present case, as can be stated in the Nalatilich case, to determine if the prisoner of war was in a real position to make a real choice regarding the employment, it must be taken into account if the prisoner of war was paid and the general conditions under the prisoner were at the time of the laboring. As stated in the statement of agreed facts and also in the clarifications, the prisoners of war were at all times treated humanely, and the treatment even exceeded international standards. Also, they were paid commensurate to the nature of the work that they were doing. So,
Agent, I have two questions. First, regarding the payment and the treatment of the prisoners of war. So does that have a legal effect regarding the forced labors they were to do? And second, Article 50 of the Third Geneva Convention states that authorized work of prisoners of war prisoners of war may be compelled to do, among other, public utility services having no military character or purpose. And in this case, the prisoners of war were to transport waste. So that, in my view, could be understood as a public utility service. So what's your country's standing on that?
thank you for your question, Your Excellencies. Answering to the first one, we contend that the payment has to be taken into account since it is a requirement or an element that has to be taken into account in order to determine it was forced labor or not. As established in the Nalatilich case, in order to determine so, it must be considered if they were paid. In the present case, the prisoners of war were paid, and not only paid, but they were paid for the nature of the work that they were doing. So it must be concluded by this court that the prisoners of war were in a position to make a real choice regarding the employment. So
Why should we make that assumption? Payment is not synonymous with consent. It's after the fact. You pay someone after they've worked. The question for us is, was there consent ex ante, the work that was being done, and was this consent documented in any way?
Your Excellency, in the statement of agreed facts, there is no evidence of the consent of the prisoners of war. However, in this same case, it is established that when consent it is not evidenced in the facts, it must be presumed by the general conditions under the prisoners' work.
What's your authority for that?
is the nullity case, Your Excellency, of the ICTY Tribunal. Your Excellencies, the applicant stated that as it was involuntary, the employment was unlawful under Article 52. However, we request this court to determine that the prisoners of war were in a position to make a real choice regarding the employment. So Ragnall complied with Article 52 of the Third Geneva Convention. And answering to your second question, Your Excellency, the public utility, in accordance with Article 50 of the Third Geneva Convention, it is a matter that had to be taken into account when employing prisoners of war, since they can be employed, in fact, in the humanitarian rules when there is a public utility reason. In the present case, the applicant has also failed to establish that the general context of the Guys Peninsula, and particularly the Tintagel Park, was that accumulation of the waste was provoking an unprecedented health and environmental calamity, which could even injure the prisoners of war or even the state of Agloville. For this,
The fact that the waste was hazardous interplay somehow with Article 50 of the Third Geneva Convention.
Your Excellency, we contend that there was a public matter since it could harm the population health. However, in accordance with Article 51 of the Third Geneva Convention, the detaining power shall provide suitable working conditions, which in the present case, they were provided of safety gear, including masks and gloves. In accordance with the Centers for Disease Prevention and Control, the masks and gloves are adequate for the collection of hazardous wastes and even medical wastes, which is the present case. For these reasons, we contend that Ragnall complied with the relevant provisions regarding the treatment of prisoners of war under the treaty and under international humanitarian law in accordance with Article 22 of the treaty. For these reasons, we contend that Ragnall complied with its obligations regarding the employment. But regarding the second submission, Your Excellencies, we contend that Ragnall complied with its obligations by transferring them to Calam Correctional Center. Your Excellencies, the applicant has also failed to establish the general context under the prisoners of war were at the time they were transferred, since when the transferring took over, they were in a real danger since the Fort Calion and the combat zone was getting closer. The Fort Calion was the first location under the prisoners of war were at first. So the combat zone was getting and becoming a danger zone. And Ragnall had no other measure than to transfer them to Calam Correctional Center, in which they could enjoy the same general conditions that even exceeded international standards as established in the clarifications. For these reasons, we contend that Ragnall complied with its treaty obligations by transferring them to Calam Correctional Center.
Wasn't there a better alternative to a maximum security prison? I mean, they were brought out from a fort, which is a military facility, and transferred to a maximum security prison. How does that meet the requirements of the Geneva Convention?
Your Excellency, it must be noted that in accordance with the paragraph 2 of the Statement of Agreed Facts, the belt is an inhabitable region whose only habitable part is the Tintagel coast. The Tintagel coast was in hostile activities, so the prisoners of war could be danger in getting closer to the active hostilities. So Ragnall had to transfer them to a prison in Calam Correctional
No,
Center.
I understand why they had to be transferred. That part you made very clear. My question is, wasn't there a better alternative to house these individuals than a maximum security prison within the territory of Ragnall?
Your Excellency, we contend that there was no other measure, since in this Calam Correctional Center, they can enjoy the same conditions that exceeded international standards, and they can have the adequate living and accommodation as regards the obligations of the detaining power in accordance with international humanitarian law. For these reasons, we contend that Ragnall complied with the treaty and by humanitarian obligations by transferring them to Calam Correctional Center. Regarding pleading D, Your Excellencies, this agency has two main submissions. First, that Aglovale was the one that uncomplied with the treaty by conditioning the treatment of the waste. And second, that Ragnell complied with the treaty obligations by exporting the hazardous wastes to Edna. Your Excellencies, in accordance with the statement of agreed facts, it must be noted two different times and conduct. First, the Ragnell's request to Aglovale to cooperate in order to mitigate the harm that the accumulation of the waste was provoking in the Guys Peninsula. And second, the request that Ragnell made to Edna in order to prevent any other and further environmental harm in the Tintagel Park.
So is your country affirming that the Aglovale's obligation to cooperate in good faith is absolute then? Or what's the standard of good faith, if there is such a standard?
Your Excellency, in accordance with the Gachiko-Bunagimaros case, in order to the cooperation to be in good faith, it must be meaningful. In the present case, as established in the paragraph 39 of the Statement of Agreed Facts, Aglovale and Ragnall indeed gathered to negotiate the managing of the waste. However, they, and especially Aglovale, was the one that committed to resume the conclusion of the negotiations in December 27, but it canceled arbitrarily.
So the cessation of the negotiations was related to the acts of aggression conducted by your country, wasn't it?
Your Excellency, the applicant justified the cancellation of these negotiations because of the acts of the respondent. However, as my coalition has established, the measures that Ragnall take in order to preserve its security was lawful under international law. So, as stated in the Gapchikovo-Nagimaros case, the applicant cannot justify its actions of refusing to cooperate by the Ragnall's action. For these reasons, we contend that the meaningfulness of the element of good faith in cooperation is not complied, since Aglovale arbitrarily canceled the negotiations that were to resume in December 27. And it's for that reason that
I just wonder if you're familiar with any precedent whereby a country that suffered an armed attack kept with negotiations with the country that conducted such an armed attack.
Your Excellency, as in the construction of a road case, we can make a similar assessment since Nicaragua and Costa Rica were in conflict. However, in the present case of the construction of a road, the court came to the conclusion that they were obliged to cooperate in order to mitigate environmental harm. In the same sense, the Nuclear Weapons Advisory Opinion establishes that the environmental duties have also been taken into account in armed conflicts. For these reasons, we contend that the applicant failed to comply with its obligations stated in Article 28 of the treaty by refusing and arbitrarily cancel the negotiations.
I have a question on your standard of cooperation. Now, there are some facts in the briefs and in the papers about the upcoming expiration of the lease. And there are also some facts about Balan's repeated invitations to Ragnell to participate and engage in discussions about the upcoming expiration of the lease. It appears from the papers, and correct me if I'm wrong, that Ragnell never engaged in such invitations and negotiations. So my question is, what is your standard of cooperation when it comes to your state and your participation in cooperative negotiations versus Aglovale's participation in other negotiations? Would you say that your state acted cooperatively in that context?
Yes, Your Excellency, we will submit to this court that Ragnell acted properly since, at the difference of the Aglovale's contents, Ragnell was entitled to conditioning the cooperation since its nationals were injured without any provision of necessity or
Conditioning
compliance.
the negotiations. There you go. That's the point. Conditioning the negotiations. Wasn't this act by Aglovale a condition, an appropriate conditioning of negotiations in the same line as what you're describing?
Yes, Your Excellency. However, in the present case, Ragnall did not commit any international wrongful act. In the case of the deaths of the Ragnellians that were injured and dead because of the destructions and bombings of the UAC fighters, it must be determined that Ragnall was entitled to protect its nationals and its national security. For this reason,
That's the question for us to decide. But you see my dilemma here. You have two situations in which a state is claiming that it will not participate in negotiations because some international wrong is happening to them. So in the case of Ragnell, it was the murder of civilians within the belt. In the case of Aglovale, it was the attack on that gateway. So how do you differentiate these two?
since the measures taken by Ragnall were in accordance with the principles of humanitarian law, and there is no evidence in accordance with the attacks to Ragnellian nationals that they were in accordance with the humanitarian international law, or even in accordance with human rights law, Your Excellency. However, we contend that Ragnall complied with its treaty obligations by exporting the hazardous wastes to Etna, since it was necessary to prevent any environmental damage that the accumulation of the waste was causing, as predicted by industrial experts in accordance with paragraph 38 of the Statement of Agreed Facts. This is also in accordance with the prevention principle that it is established in Article 28 of the treaty, and it is a customary international rule in accordance with Principle 2 of the Rio Declaration, which this court has determined to be customary international law in cases such as the Pulmius. Your Excellencies, the applicant stated that the respondent failed to comply with Article 11 of the Bristol Convention by failing to comply with the agreement with Etna. However, the responsibility of Ragnell was to assure that the environmental wastes will be in adequate facilities, and this as means of cooperation. Your Excellencies, in accordance with the Statement of Agreed Facts, paragraph 44, Etna was the one that committed to treat the waste management in an environmentally sound manner. The principle that the applicant said that Ragnell failed to comply. However, it complied with the responsibility to assure that Etna had the adequate facilities to do so. Moreover, the state of Etna was the one that committed to comply with the principle of, I'm sorry, Your Excellencies, I believe my time is over. May I briefly conclude?
Please do so. And on this particular matter, would you say that Ragnell took the necessary measures, the due diligence that was required in order to make sure that Etna could, by all means, comply with the duties it had in terms of disposing of the waste, because it was highly criticized afterwards because Etna was not competent enough to dispose of this waste.
Thank you, Your Excellency. In accordance with the Cachicobonagi-Maros case, the cooperation principle has to be taken into account the trustmanship and the confidence with the other state that they are cooperating with. In the present case, as Etna made an unilateral declaration to have the adequate facilities, it had to cooperate in good faith and assuming and complying with the due diligence duty by this declaration. For these reasons, we contend that Ragnell complied with its treaty obligations by exporting the hazardous wastes to Etna, whereas Aglovale was the one that uncomplied with the treaty by conditioning the treatment of the waste. May it please the court, Your Excellency.
Thank you. Thank you very much indeed. Right. Now, the applicant has the right for rebuttal, and it will have 2 minutes to present its views on this particular matter. Please proceed.
A very efficient rebuttal.
With the permission of the court, Mr. President, Your Excellencies, in the following 2 minutes, I will address why this court should rule and adjudge in our favor. Firstly, the first agent for the applicant stated that there was a state practice on self-defense against non-state actors. Nevertheless, he only said the events of 9/11 were the state practice. Nonetheless, Your Excellencies, this one event cannot be considered as state practice of self-defense against non-state actors. Adding to this first point, regarding the claim of the agent of Ragnall regarding the attack on Compound Arden and Gateway, the principles of proportionality and precaution were indeed violated, given that there were civilians in the belt, as seen in paragraphs 42 and 48 of the Statement of Agreed Facts. Not knowing that there were civilians in the belt evidences Ragnall's failure to comply with its obligations of proportionality and precaution. The second agent for the respondent also referred that an obligation to cooperate was regulated in customary international law and case law. However, we must not forget that the parties were primarily bound by the obligation to cooperate contained in the treaty, which was not unconditional, as I mentioned in my exposition. Ragnall's requests had to be reasonable and necessary, and they did not comply with neither of those requirements. Regarding the transport, the second agent for the state of Ragnall referred that EDNA had obligations to manage the waste in an environmentally sound manner. However, that does not preclude the obligation to do a due diligence and to make an environmental impact assessment by the state of Ragnall, which they evidently violated, as can be seen in paragraph 45 of the Statement of Agreed Facts. Your Excellencies, Mr. President, may it please the court.
Thank you. Thank you. Now, the respondent has 2 minutes for its rebuttal.
Mr. President, Your Excellencies, 3 points for rebuttal. First, the applicant stated that the state of Ragnall did not use the principles of humanitarian law at the times of the attacks. However, it must be noted by this court that in accordance with the Statement of Agreed Facts, the evacuation of civilians were taking over when the attack to the Compound Arden took place. For that reason, the state of Ragnall took the necessary precautions, as stated in the additional protocol 1, to be lawful this measure against the Compound Arden. Moreover, it was necessary the attack to Gateway, since it was used as a transport for weapons, and it was to prevent a surprise attack that could affect the whole Guys Peninsula, in specifically the Clarence Belt. Regarding the second point of the rebuttal, Your Excellencies, the applicant stated that the request was not reasonable. However, we contend that was reasonable because it had a legitimate aim in accordance with the commentary 36 of the general comment of the ICCPR, since it had the legitimate aim to prevent environmental damage not only for the state of Ragnall, but also to the same state of Agloville. Your Excellencies, in accordance with the Paul Mills case, the prevention principle has always been taken into account. In the present case, it was used by the state of Ragnall when it prevented any environmental damage by the accumulation of the waste in the integral park. May I please record your excellencies?
Thank you. Thank you very much. Right. Well, now we come to the end of our submissions and presentations by the parties, and the court will retire to deliberate and determine the judgment on the case. Thank you very much.
The spectators and councils, please remain in the room, and the judges will exit the room to deliberate, please. Tomamos asiento, por favor. Ya en unos minutos vienen los jueces para la premiación.
Antes de hacer los anuncios pertinentes sobre el desarrollo de esta sesión judicial, los tres integrantes de la Corte quieren dejar registro de su complacencia por la calidad de las presentaciones que se han hecho. Es decir, nos quedamos muy gratamente impresionados por el hecho de que el applicant y su contraparte han tenido una actuación excepcional que realmente resulta altamente satisfactorio para la Corte encontrar gente tan competente, tan bien entrenada y que ha estudiado también el caso. Quise dejar constancia a nombre de mis colegas de la complacencia que nos significa el que esto haya ocurrido así. Muchas gracias.
Muchísimas gracias, embajador. Sí, vamos a proceder con la clausura del evento. Saludarlos. Coincido con el embajador Sepúlveda sobre una ronda intensa e interesante. Mi nombre es Miguel Reyes, soy consultor jurídico adjunto en la Secretaría de Relaciones Exteriores. La consultoría jurídica es la oficina en la Cancillería que representa al Estado mexicano ante tribunales internacionales y extranjeros y que se encarga de asesorar al canciller en temas de derecho internacional público y privado. Por esa razón nos congratulamos mucho en tener la organización de este concurso y sobre todo de poder contar y de poder recibir a todas y todos ustedes con estas jóvenes promesas del derecho internacional, que en esta edición del concurso se inscribieron 10 universidades de públicas y privadas de la República Mexicana, situación que no es menor y que también nos da muchísimo gusto. Primero, porque el número de universidades va creciendo exponencialmente cada año. Es muy importante que esto siga creciendo porque la difusión del derecho internacional en nuestro país debe ser tan importante y tan prioritaria como de cualquier otra rama de derecho. En este concurso, para nosotros también es muy, muy importante y le tenemos mucho cariño, porque además de esta gran demanda de abogadas y abogados y internacionalistas que el país requiere, también es un concurso que nos va a otorgar muchísimas habilidades profesionales para la vida profesional, no importa a lo que ustedes se dediquen. Estas habilidades son no solamente se traducen en la habilidad para responder bajo presión, la habilidad para adaptarse a los cambios, la habilidad de argumentar, que es argumentar oralmente, sobre todo en un país de tradición ius civilista, en el cual no estamos tan acostumbrados a tener esta interacción. Son habilidades que definitivamente todas y cada uno de ustedes van adquiriendo a lo largo de esta edición. También es muy importante resaltar que el espíritu de esta competencia, evidentemente, son todas y todos ustedes, las personas que participan en este concurso. En esta edición tuvimos a 61 estudiantes y personas asesoras, que acompañaron a todos los equipos, y también tuvimos la participación de 44 jueces y juezas, en donde logramos este año una paridad de género entre las personas que sirvieron como jueces y jueces, lo cual es un reflejo precisamente de cómo este concurso va permeando y vamos lograr esta paridad en todas las esferas. Quiero agradecer particularmente al bench que nos acompañó en esta final. Muchísimas gracias. Al embajador Bernardo Sepúlveda, al maestro Rafael Llano y a la maestra Liliana Oliva, un bench de primer nivel. Muchísimas gracias por acompañarnos en esta edición. Y no tenemos duda que los dos equipos que se enfrentaron el día de hoy, que van a estar representando a México en la final, van a hacer un papel espectacular. Les deseamos muchísimo éxito en las rondas internacionales que van a ser en abril. Vamos a estar muy al pendiente de las rondas porque nos emociona de verdad muchísimo cómo un país, una escuela que va representando al país, va avanzando y se va abriendo paso. Muchísimas felicidades por su participación en esta edición y muchísimo éxito a las dos universidades. Entonces, dicho lo anterior, vamos a la parte más emocionante de esta tarde, que son las premiaciones, y me permito abrirlas con el premio The Spirit of the Jessup, que es un premio que va elegido por todas y todos ustedes, los participantes. Y el premio a The Spirit of the Jessup de este año es para el equipo número 369, Universidad Nacional Autónoma de México. Los centímetros, muchísimas felicidades.
Bueno, buenas tardes a todos. Me toca a mí presentar los diplomas, los premios a los mejores memoriales. Antes de eso, solamente un minuto para felicitar a los dos equipos que me tocó ver hoy y la verdad fue un placer verlos a los dos equipos. Se mencionó hace un momento las habilidades que les van a servir para toda la vida en este contexto y uno podría preguntarse en qué forma. Y la que a mí me parece más obvia y evidente, aparte del talento, que claramente lo tienen a borbotones los dos equipos, es la disciplina y la preparación. Y el nivel de intensidad que le han dedicado, evidentemente, ambos equipos a estar aquí el día de hoy, me llena de orgullo en ver esta generación de youth internacionalistas que van a dedicarse a esto en el futuro y quisiera felicitarles por eso, por esa preparación, esas horas extras que le dedicaron, esa noche en vela, ese tiempo extra para llegar aquí. Es algo que les va a servir en cualquier faceta de la vida y ciertamente en esta profesión. Así que muchísimas felicidades por eso. Con eso, a los memoriales. Mejor memorial del applicant va para el equipo 284, el CIDE. Mejor memorial del respondent, equipo 284, el CIDE. Y antes de que se me vayan, mejores memoriales combinados, el CIDE.
Bueno, pues emulando a mi colega Rafael Llano, antes de hacer el anuncio de los premios a los mejores oradores en rondas preliminares, quiero empezar por felicitar a todos los equipos. Evidentemente los dos finalistas hicieron un trabajo estupendo, estamos verdaderamente impresionados por el nivel de esta final. Pero quiero también felicitar a los 10 equipos participantes. De hecho, nos comentaron que hay algunos equipos que vinieron por primera vez a Jessup. Y pues quisiera decirles que todos los que están aquí ya ganaron. Se van a llevar verdaderamente herramientas profesionales y personales que les van a servir para todo lo que venga. Que no tengo la menor duda que va a ser un camino profesional sumamente exitoso. Y sumando a las observaciones de Rafael, le quisiera decir que también con este trabajo que vienen haciendo desde hace meses, no saben cuánto aprendieron en dos cuestiones fundamentales: trabajo en equipo y trabajo bajo presión. Esas dos herramientas que han estado trabajando estos meses con absoluta fluidez, por lo que hemos visto, van a ser esenciales para su camino profesional. Enhorabuena por animarse a venir a este concurso tan demandante, de tan alto nivel, y en el que en muchos casos pues ustedes no van a ver un reflejo en número en sus calificaciones, ni mucho menos, ¿no? Renunciaron a mucho tiempo libre por este ejercicio, pero que créanme que van a acordarse de este día en el futuro y decir, wow, sí valió la pena esa inversión. En adición a que yo no tengo duda alguna de que estos equipos que vinieron por primera vez van a estar aquí el próximo año y los años subsecuentes. Así que muchas felicidades a todos y pues bueno, procedamos con el anuncio a los mejores oradores en las rondas preliminares. El premio al tercer mejor orador en preliminares es para José Emilio García. La segunda mejor oradora de las rondas preliminares es Ana Irene Prados Casep. Y el premio a la mejor oradora de las rondas preliminares, el primer lugar en preliminares es para Emilia Silva Cruz.
Yo también quisiera hacer una introducción al anuncio que habré de hacer de inmediato con relación a lo satisfactorio que resulta el participar en eventos de esta naturaleza. Una de las grandes complacencias que advierto es el hecho de que se estén formando internacionalistas mexicanos de alta calidad. Quizás sea una cuestión de generaciones. En el caso mío, mi generación tuvo un muy exiguo interés por el derecho internacional, por el estudio de la política exterior, por la participación de México en asuntos internacionales y nos vimos privados en esa generación de gentes que tuvieran una participación tan intensa como la que ustedes están teniendo en temas internacionales. Debo decir que para México resulta absolutamente indispensable contar con internacionalistas de alta calidad y alto nivel. Me resulta extremadamente grato advertir que en estas épocas existe un talento importante en materia de asuntos internacionales. Es decir, la vocación que ustedes han demostrado, como ya lo dijo Liliana y lo ha manifestado también Rafael, para sacrificar horas y horas de trabajo en el estudio de una disciplina tan importante como lo es el derecho internacional, el haberse metido al examen de un número significativo de casos que en muchas instancias son quizá no suficientemente conocidos y que ustedes han manejado con una maestría admirable, significa para todos nosotros un motivo de satisfacción enorme. Yo les invito a que continúen ustedes en las tareas de la disciplina internacional. La disciplina internacional en su conjunto. Es decir, ustedes lo han manifestado ahora como juristas internacionales y yo tendría la esperanza de que hacia el futuro México tenga en todo caso, en toda circunstancia, la posibilidad de contar con personajes debidamente entrenados en el derecho internacional, que sepan defender lo que es el interés nacional. Me toca entonces anunciar quiénes son los que han sido considerados como el mejor orador de la ronda final, y el nombre es Ricardo Lozano. Y ahora me toca el deber de anunciar quién es el campeón nacional del Jessup 2023. Y este es el equipo 161 de la Universidad Panamericana, Campus Ciudad de México.
Muchísimas gracias, muchas felicidades al equipo ganador. Pues con esto clausuramos esta edición del concurso y muchísimas gracias a todas por su participación.
Salvo la mejor opinión de la Administración Nacional, podríamos tomar alguna foto con los equipos finalistas, con todos los equipos.